But with that said, let's get started. I'm very excited to introduce our first webinar and our speaker. We always start off the year with a labor law workshop because it's one of the most important things going on. And we have the amazing Kristina Kourasis, who is a labor and employment attorney with the law offices of LANDEGGER, VERANO, and Davis. And they're based in Encino. Kristina is also on our board of directors. They serve the whole greater LA area and all over Southern California, and she's one of the top rated employment lawyers in the San Fernando Valley. She received her JD from Southwestern Law School in 2011, where she served as a judicial extern, and she received her BA with honors from the University of Southern California in political science with an emphasis in philosophy. Before joining LANDEGGER, VERANO, and Davis, she ran a solo practice devoted to advising employers in employment law matters and representing employees in a wide variety of employment disputes. In order to broaden her understanding of the employer-employee relationship, she subsequently specialized in complex business litigation, focusing her practice in areas of employment, employee benefits, and healthcare litigation. And when she came to LANDEGGER, VERANO, and Davis, she discovered her passion for educating, training, and advising and defending employers in all areas of labor and employment. And she's been a frequent presenter for us. And she's also very recently started helping a lot of our members and even non-members with their website compliance issues, because that's a very big thing right now where businesses are being sued for not having an ADA compliant website. And so we've referred Kristina several people and she's been helping them as well. So there's a whole other gamut out there that still has to do with your business that Kristina or one of her colleagues can help you with. So I'm going to turn it over to Kristina to start our webinar. Thank you everyone for being here and Happy New Year.
Thank you for the introduction, Nancy. Good morning and thank you for joining us this morning for Business in Focus webinars. Happy New Year, everybody. So for 2023 legal update, California legislature and Governor Newsom were busy yet again in 2022, and they've implemented some fairly broad changes that will affect a lot of companies and California employers. So let's go over the key bills so that you are in the know. Okay, so first things first, the most important part is let's make sure that you guys are paying enough to all your employees. And the first thing that I have on my list is the California state minimum wage. As you may know, the California minimum wage has gone up, and the amount that we're looking at is $15.50 as to all employers, regardless of employer size. So whereas before it was split up into more than 26 versus small employers, now it's regardless of size. If you are a California employer, you have to pay $15.50 per hour to all your employees. Originally, the minimum wage was scheduled to increase to $15 per hour. I'm not sure if you guys were tracking this, but due to high inflation, I guess the state of California decided that the high inflation really triggered a rate that goes beyond $15 per hour. So effective January 1st, 2023, that's what we are faced with. Keep in mind, whereas before 2023, there was an expected jump. And I think a lot of us had a copy of this chart that we kind of looked at and said, okay, next year, this is where we're going. This year, this is where we are. In the foreseeable future, what you can really expect is the minimum wage to increase based on the National Consumer Price Index. So based on inflation, the state of California can say, okay, our next minimum wage is going to be X, okay? So stay tuned for that. And if and when anything changes, I'll definitely notify you guys and let you know that you need to keep up, okay? As always, there are also local minimum wage increases. So definitely keep an eye out for things that pertain to to your city, to the city where you conduct business. For example, effective July 1st, 2022, as I'm sure you know, City of LA went up to 1604 and the County of LA went up to 1596. Let's go to the next slide. Accordingly, because as you know, based on the state of California minimum wage, the state of California also increases the annual wages for exempt employees. So there's now an increase as a result of this increased minimum wage per hour. It translates into an increase for the exempt salaried employees. And obviously, we want to make sure that the duties that those employees are performing meet the duties test based on the type of exemption that they fit into. So if they're in the administrative, executive, or professional exemption, you want to make sure that they're making at least $64,480 annually, and that they also are performing the duties that fulfill that duties test. If you have any specific questions, I'd be happy to address them at the end. Keep in mind that in addition to these regular exemptions, there are also industry-specific exemptions, including computer professional exemption, which has gone up significantly to $112,65 per year, which translates into over $9,000 per month. And again, keep in mind, as to computer professionals, I know some of you are in the industry. This is an extremely convoluted, complicated test. So you want to make sure to look at the requirements and make sure that your employees are actually falling within that exemption. Typically, what I look at is the employee performing things that a regular computer person cannot perform? And if the answer is yes, then it's likely that they are exempt. But again, I'm being facetious. This is a very complicated test that needs to be looked at very carefully. So if you are classifying someone as exempt under the computer professional exemption, make sure that they actually fulfill the requirements. Let's go to the next thing. And I know a lot of you had questions about this. This is SB 1162, and it significantly amends and expands California's pay transparency and pay disclosure requirements. Before SB 1162, California employers were required to provide a pay scale to applicants upon request by the applicant, but only after an initial interview. Now, due to the expansion, applicants no longer have to wait until an initial interview. So they can now make the request. Now, just to be clear, pay scale is basically the salary or the hourly wage range the employer reasonably expects to pay for the position, whatever the position is. Now, keep in mind, I think a lot of people are confused about this. There are three categories of requirements, and one category that applies to all employers regardless of size. Second category that applies to only employers that have at least 15 employees or more. And the third category of requirements applies to employers who have 100 plus employees. Okay, so we're going to start with the category that has that applies to all employers. And under this category, you must establish a pay scale for all positions. You must provide the pay scale information to applicants, like I mentioned, upon reasonable request. And like I said, whereas before it was post-interview, now it can be right away, right? In fact, it should be something that is posted in the job description, in the job ad that you're posting on LinkedIn or wherever you may be posting it. Okay, so you must respond to requests from current employees as well by providing pay scale information for a current position. along with those requirements that apply to all employers pertaining to what you have to disclose, there's also record keeping requirements, okay? And essentially you have to keep a record of the specific job title and wage rate history for each employee, not just throughout their employment, but also 3 years after the employment ends. Now, the next category I'm going to go to is the category of requirements that applies to employers with 15 plus employees. Okay, so you want to make sure that, again, you're including a pay scale information in job postings. So if you're posting a job ad on any website, Indeed or LinkedIn, you want to make sure that you have a pay scale that goes along with that. And also that applies to third parties. So if you are using a third party company that is helping you fill the position, you want to make sure that their ad also contains the same information in the job posting. Okay. At this point, there are a lot of questions about this, which some of which I'll try to answer, but I just want to make you aware that you need to watch out for further guidance that will come out from the DLSC, because this is still in the process of being refined. Okay, so the next category we're going to go to is a list of things that are required that are applicable to employers with 100 plus employees. Okay, so what you want to be aware of is that there's now more things that you have to report in a nutshell, right? There's a lot of like details as to what you do have to report. So I have this bullet pointed in here. You got to report the median and mean hourly rate for each job category. And it's broken out by race, ethnicity, sex. And you have to also submit a separate paid data report for each employee hired through labor contracts, such as staffing agencies, and disclose the ownership names of all labor contractors used to supply such employees. Again, lots of open questions, and you need to watch for further administrative guidance from the DLSC. And I strongly suggest that you really do sit down with your HR staff and or any consultants that you're using or attorneys to make sure you really nail this and prepare the correct reporting, the correct reports that you need to prepare. Let's go to the next category. So as far as the next slide, I want to just make sure that you are aware that there are deadlines that apply to employers with 100 plus employees. So the first reporting deadline is going to be in a few months, May 10th, 2023. And thereafter, it's going to be required to report every second Wednesday of May. You want to be aware that this isn't just something that they put out without enforcement. There are some actual financial penalties that are associated with this. So under 1162, if employer fails to file the paid data report, an employer may be subject to a penalty of up to $100 per employee for initial failure and up to $200 per employee for subsequent failures. So like I said, I would really consider developing a policy and identifying individuals who are going to be handling these requests and questions such that they know exactly what they're talking about and don't subject you to further liability. And we're talking about supervisors and managers. Let's go over to the next category, which is leave of absence updates. And the updates that we're going to cover today are bereavement leave, CFRA, and paid sick leave. I know your favorite things, right? Because those come up all the time. So let's jump into the first one, which is bereavement leave. And this is AB 1949, and it applies to employers with 5+ employees. And the update is essentially that employers must allow 5 days of leave upon a death of an employee's family member. And that includes spouse, child, parent, sibling, grandparent, domestic partner, or parent-in-law. Now, this is not a paid leave. So, you know, a lot of my clients have had this type of leave that covers between 1 to 3 days. Sometimes 1, 2, or 3 days are paid. You don't have to make 5 days paid. If you've had a leave that pays up to 2-3 days of employees' leave related to bereavement, you may leave it that way and then add the additional, 2-3 days, depending on how many you've had. And the rest of those days don't have to be paid, okay? The next category is an expansion to the California Family Rights Act under AB 1041. And this applies to employers with 5+ employees. And you want to make sure that you update your applicable policies to allow for a person under this expansion designated as designated person. And that category of designated person is defined as any individual with a serious health condition, which is any individual related by blood or whose association with the employee is the equivalent of a family relationship. And that individual under this new CFRA expansion may be identified by employee at the time of the request for the leave. Okay, so it's not someone who has to be identified at the beginning of employment. It can be at the time that you need to request the leave. We don't know at this point exactly who that person will be. I mean, presumably the state is trying to allow individuals who have close friends to, to go and care for them. But at the end of the day, I really think this is going to come down to what the courts really define this definition to mean. And you want to be aware that you are allowed to limit employees to only take one such leave as to designated person for 12-month period. Okay, and there is a record keeping requirement, which is that you must retain records for designated person along with the dates of the request. The next category is as to paid sick leave, and this is another expansion under AB 1041. This applies to all employers, and again, this really adds the designated person as well, but you want to be aware that this is different than the CFRA definition. Under the paid sick leave expansion, and I have it in here, the designated person is a person identified by the employee at the time the employee requests the paid sick leave. So the way I look at it is this is even broader than the designated person that was added under the CFRA. Under this paid sick leave expansion, you can literally bring up just about anyone, designate them as the designated person that you're going to identify at the time that you're requesting the paid sick leave, and basically request the paid sick leave to go care for this person, okay? There's the same limitation of one request for 12-month period for, as in CFRA leave. And again, you have the same record retention requirement as with CFRA. Okay. Let's visit the COVID-19 legislation. I'm sure this is your favorite topic and has been for the last couple of years. I just want to, here's an overview of what we will review today. I made a checklist here. There's supplemental paid sick leave, which I'm sure some of you may have questions about. COVID-19 exposure notices, non-emergency COVID prevention regulations, and extension of COVID-19 workers' compensation provisions. Okay, so let's start with supplemental paid sick leave. Okay, while the supplemental paid sick leave has expired at the end of last year, as I'm sure you've all been keeping track of, keep in mind that there are still local COVID-19 supplemental paid sick leave ordinances in effect. Okay, so for example, like for the city of Oakland, Long Beach, city of LA, and the county of LA, they've all had longer requirements for employers to satisfy. So a couple of weeks ago, the Los Angeles City Council voted to end the city's state of emergency effective February 1st, 2023. So thereby that triggered the end of the city of LA supplemental paid sick leave. Per the ordinance, that leave expires 2 weeks after the expiration of the local emergency period. So that puts us at February 15th. Okay, so just be aware of that. And
Kristina, didn't the federal government extend the state of emergency though too?
I'm not sure.
Because I just read that Becerra was going to extend it like another 90 days, so that may change. I'm just saying that may change everything.
Let me take a look at that because I was not aware of the extension.
I don't know if it passed. I'm just letting you know.
You mean as to the state or as to federal?
Well, federal, but the state has been following the federal, and then the county has been trying to follow this. I'm just saying, it's trickle down.
Yeah. As of now, the state of California has basically said that it expired at the end of the year, with the exception of the local extensions that apply because of the local ordinances. I'll take a look at what you're referring to just to make sure, so that we're all on the same page. If anything changes, I will definitely send an update to the group. So, so basically, there are local ordinances that you want to be in the loop about, because the requirements do apply to employers who operate in those areas. So, as to, for example, Long Beach, it talks about, the city council will determine based on relevant info contained in the 90-day report. And the city, like I said, the Los Angeles County talks about 2 weeks after the expiration of local emergency period. Oakland, I don't know if any of you really are in that area, but it's upon the expiration of local emergency period as well. There is a link that I will circulate. If you want to double check, like if you're in the county of LA, if you want to double check whether that ordinance applies to you, there is a way to check. There's a website to check if you are in the unincorporated area of LA, because if you do operate there, then the county of LA ordinance that's still in effect may be applicable to you. Okay. So let's go to the next one, which is the COVID-19 exposure notices under AB 2693. And as you guys probably know, since 2020, California employers have been required to provide notices of individuals being exposed or having potential COVID-19 exposure. And pursuant to this update, you basically have to continue providing notification of potential COVID-19 exposure through January 1st, 2024. And that notice, it's now a little more flexible. So I guess there's a little bit of good news. And you can post this notice not just via a letter, but you can also post it in a public place where you also post other employment updates. And the notice must be posted within 1 business day of you learning about the potential exposure, must be in English and in any language that the majority of the employees speak. And you have to retain a log of the dates and any notice of exposure in the workplace that's posted. So there's also an update to what California OSHA is doing. So I don't know if some of you have heard about this, but I just want to go over the emergency temporary standards, which the future ones are going to say non-emergency, but as of now, on December 15th, the non-emergency prevention regs were adopted, but they were not yet approved by the Office of Administrative Law. So in the interim, the emergency temporary standards, the ETS that we've had since November 2022, they're still in effect until the new regs become effective. Now, I know that on the federal level, everything has now been relaxed, okay? And I also know that the California Department of Health has also relaxed everything. But because you're a California employer, you really have to abide by what Cal OSHA says. And so, yes, we have CDPH and the CDC, but we want to also make sure we're waiting for the Cal OSHA to get up on the same page with those other agencies, okay? So as soon as we get more information, we will circulate it. But this is just a brief update per the older requirements. I have posted these just in case you guys need a refresher. We'll go through them really quickly, but essentially this one is for employees who test positive, and the requirements apply to all employees regardless of vaccination status, previous infection, or lack of symptoms. And basically employees who test positive for COVID, they have to be excluded from the workplace for at least 5 days after the start of symptoms, or after the date of first positive test if no symptoms. And isolation can end and the employee can return to work after day 5 if the symptoms are not present or are resolving and you've got a specimen collected that's negative on day 5 or later. Okay, let's go over quickly through the next category, which is those employees who were exposed to a COVID-19 case but who are asymptomatic. And again, this applies to all employees regardless of vaccination status. And those employees who were exposed, they have to test within 3 to 5 days after the last contact. And employees have to wear a mask if they are at work for a total of 10 days after exposure. This next category is for those individuals who were exposed but who are symptomatic. They have symptoms. And again, this applies to all employees regardless of vaccination status. And this category of employees, they have to be excluded and test as soon as possible. And the employee can return to work if they get a negative test from a COVID negative test at least 5 days after the start of symptoms or first positive test result. And they have to wear a mask similarly for 10 days, especially when indoors. Otherwise, if the employee is not following, if the employee is not getting the negative test and or they're not wearing a mask, then they basically cannot return to work until at least 10 days have passed since their symptoms began. Okay, that's just a quick rundown of that as a reminder. So employees are also filing more wage and hour class and PAGA representative actions, way more than even before. I know it seems impossible, but it really is a prevalent practice now. So I want to make sure this is just a quick slide, and There are additional developments in the wage and hour arena that I'm not gonna go into now. This is sort of that I consider the most important one I wanted to put on your radar, but there's a few other ones that are more nuanced, but just as important. And I'll have an additional topic presentation and a different PowerPoint for that discussion that's going to be presented at a later time. But this specific one pertains to meal and rest break practices because almost every wage and hour and or PAGA or class case that we have with our firm has to do with meal and rest break practices. This is very prevalent. There's a case that came out in 2022 that basically out of California Supreme Court that confirmed that the 1 hour premiums that are due for non-compliant meal periods or rest breaks constitute wages under California Labor Code. So what that means is that these owed meal and rest break premiums that may be owed as a result of a defective meal or rest break are now triggering statutory penalties for inaccurate wage statements and waiting time penalties, which really compile. So I know I'm going through this very quickly, but please make sure your policy is compliant, what you're doing is compliant in practice. Otherwise, this is going to cost you tons of money and headache in the long run. And stay tuned for my next presentation on this. Let's dive into this next one. And this new legislation basically is pertaining to a new category. It amends the Fair Employment and Housing Act by adding reproductive health decision-making as a new protected classification under FEHA. What this means is that this category may be included in the existing protected category of sex under FEHA. And just to clarify, reproductive health decision-making includes things like decision to use or access a particular drug, device, product, or medical service for reproductive health. So I'm sure we'll be seeing more guidance in the upcoming months on this. But as of now, flag it, make sure you are aware and that it is added as a policy. Let's go through some of these quickly. This new legislation basically is SB 1044, and it pertains to emergency conditions. It basically prohibits an employer in the situation where the employee has a reasonable belief that the workplace is unsafe from taking some kind of adverse action against that employee, in other words, retaliating against the employee for having a reasonable belief that the workplace is unsafe. And with some exceptions, employers are also prohibited from any employee from accessing their mobile device or other communication devices to get emergency assistance, assess a situation's safety, or communicate with someone to verify their safety. Okay. Again, I recommend that you update your policies and your employee handbook and cell phone policies accordingly. Okay. This next one pertains to the mandatory retirement savings plan. And what it is it is an amendment. And since June 30th, 2022, employers with more than 5 employees had to be required to offer this retirement plan, either through the Cal Savers program or private market option. And this is an extension of that. What this does is it extends this requirement to much smaller employers. So now, before it was 5+, now it applies to if you have at least 1 or more employees, then you're on the hook for providing this type of plan. Okay, and I think that there is a carve out for under this legislation for sole proprietorships or self-employed individuals and businesses that don't employ individuals other than the business owner. So I know that's going to be one of the questions. So if you're the business owner, if you're that one employee, then you're excluded. You don't need to comply with this. Okay. The next one is the employee restroom access to members of public with certain medical conditions, and it requires businesses open to the public that have restrooms for employees to allow individuals who have certain conditions, medical conditions like Crohn, ulcerative colitis, irritable bowel syndrome, or any other similar medical conditions to use employee restroom during business hours. So consider training employees on this new obligation if you're open to the public to make sure that you are compliant. The next one is AB 984, the motor vehicle tracking, and it basically requires the Department of Motor Vehicles to allow vehicle location technology on fleet vehicles. It prohibits employers from using those devices to monitor employees except during work hours. So again, you cannot monitor an employee where they're going, what they're doing post work hours. And only if it's absolutely necessary, even during the work hours, for the performance of the employee's duties. And employers that do install the tracking device, they have to provide employees notice about the monitoring so that employees also have the right to disable that device during non-work hours if they want to, but technically it wouldn't even be necessary, but because as an employer, you're not really allowed to track them outside of business hours. Okay. The next one is data privacy policies. And with this next one, you want to determine if your business is covered by the California Consumer Privacy Act, CCPA, and the California Privacy Rights Act, CPRA. And it applies, I have this checklist here for you, so you can determine that. It applies to for-profit businesses, doing business in California, and that meet one of the criteria. You're making gross annual revenue of over 25 mil, or you buy, receive, or share the personal identifiable information of 100,000 or more consumers, or you derive 50% of annual revenue from selling or sharing consumers' personal information. Okay. And if so, if it does apply to you based on the criteria I've outlined, then consider planning and implementing a compliance program in connection with employees, applicant personal information, including the bullet points I have here, identifying which data is subject to CCPA requests. You got to update your privacy policies, whether they're on your website or in written form that you provide. You plan for processing privacy requests, and absolutely train your employees and or vendors who will be implementing this plan. And you want to also update the existing notices of collection and data security protocols so that employees and applicants know exactly what you're using, what you're collecting the data for, and have all the all the warnings and disclosures in that notice so that you are compliant. Okay, so we have a little bit of time left. At this time, I will take any questions anyone may have.
So Kristina, I'll read you the questions, but just give me 1 second to
Sure.
So let's start. I gotta scroll up. Give me a second.
Okay.
Let's see. Okay, so the first question someone had asked about, I think when you were talking about the exempt employees. That's for the whole state, correct?
Correct, yes. That's based on the state minimum wage, yes, only. It's not based on the local. So it's based on the state hourly minimum wage.
For the job posting,
Yes,
if they use social media like Instagram or Facebook, are they still required to post the pay scale?
absolutely. It's so important. I can't even begin to explain this to you. It's gonna be so easy for the administrative agencies that are enforcing this to crank down on companies, because all they have to do is go on any social media and go and find ads that don't comply. And they can track back to who you are and what you're doing, and then basically go after you. So if and when in doubt, absolutely, if you're posting anything publicly in search of a, to fill a job position, absolutely follow with a scale, a pay scale.
Okay. How does the Pay Transparency Act, okay, I've just expanded my screen and now I lost everything. How does the Pay Transparency Act apply to out-of-state employers with one or more employees in California?
Okay, so the Pay Transparency Act requirements that apply to all employers are going to be applicable to that specific situation. So if you have one employee in the state of California, you're going to be subject to the requirements of, essentially providing the pay scale to the applicants and the current employees, and you're going to have to also make sure that you are keeping the record of the specific job title and the wage rate history for each employee throughout the employment, as well as 3 years after the employment ends. So that's how you would have to comply with that, because it's based on how many employees you have in California.
Okay. And then, earlier you were talking about how the minimum wage went up, but if you have employees in another state, whose minimum wage do you follow?
So California wage and hour laws are only intended to apply to California employees and residents. Okay, if you have employees who never travel into the state of California, and who perform work remotely, or who perform work outside of the state of California, then you're going to abide by the minimum wage of the state where the employee resides and or works. Okay.
Okay.
Makes sense?
Yeah.
Okay.
But if you wanted to give them California's minimum wage, that's your prerogative. I just want to
You
say that.
certainly can. Yes, I have lots of clients who work across states, and they basically make it, sometimes it's a decision to make it easier for payroll, because if it's a difference of a couple of dollars, you just make a uniform minimum wage and be done with it. But in other instances, if the difference is, $6-7 between states, then I understand there's a need to really pick and choose what you're going to do.
Okay. Is there a minimum number of days of paid sick leave for all employers?
So, yes, absolutely. The minimum number of paid sick leave for all employers in the state of California is 24 hours. Okay, so if you're in the state of California and there is no local ordinance, for example, the city of LA, which requires 48 hours, a greater amount, then you are subject to that 24-hour minimum requirement.
So basically an 8-hour day, that's 3 days if it's
Correct.
24 hours, and
That's
6
3 days
days.
for 8 hours,
And if
yes.
you're within the city of Los Angeles, that means that's 6 days.
Correct.
But you can still give it to them by an hour, however, you decide to do that internally. They don't have to take 8 hours is what I'm saying. If they're sick,
yes.
they want to take half a
Yes.
day off or 2 hours
Correct.
off, they still get
Correct.
it for those 2 hours. It's not, it's
Yes.
like you could carve away at that
To
24
break
hours.
it up into smaller chunks for sure. And I believe that the requirement is that there's a minimum of 2 hours. So in other words, you're supposed to break it up into 2-hour increments if you're not going to take the whole day off.
What if you have an employee that wants to use their sick leave, and this is you're like, if I'm just saying, employee comes to me, I want to go to the dentist, and I'm
Mhm.
going to take an hour of my sick leave for that time.
Right.
You still have to give them 2 hours?
Well, if you're gone for less than 2 hours, is that what you're asking?
Yeah, yeah,
Yeah, I mean, if you're gone for less than 2 hours, then it kind of depends. Most employees won't even want to take paid sick leave. They'll
right.
just work longer that day if it's that small. They'll just work it off and work the rest of the day off and then make sure they're still working 8 hours. But pretty sure the requirement is that it has to be in increments of no less than 2 hours.
So someone had employees that were out with COVID, and at their office, they get 6 days of paid sick leave, which comes to like 4 hours per month. Is COVID sick pay separate than regular sick pay? And do we even still have COVID sick pay? I thought they took away from that.
So we still have COVID sick pay. Are you talking about exclusion pay or are you talking about supplemental paid sick leave? Because COVID sick pay is kind of a loaded term. I think you're referring to supplemental paid sick leave.
Yeah,
As we discussed earlier, expired on December 31st, 2022. And Nancy, I will check into any federal updates because, there are updates almost every day. So it's kind
I,
of hard to keep track of this stuff.
they
But
they expanded it in December for another 90 days.
okay, so I will check into that because if it's federal, which reminds me of like FFCRA, it may be it may be that only select employers are subject to this, right?
Right.
So I'll have to check and let you know, but usually it pertains to like larger employers. But
I'm sorry to interrupt, Nancy. That was
Yeah.
my
Yeah, I
question.
know.
So I have employees that accrue the 6 days a year, but I have two people out all week this week, 5 days with COVID. So do I need to give them the six normal days and these 5 days?
That is correct. Steve, is that your name?
Yes.
So the supplemental paid sick leave, well, based on the name, it's on top of what you owe, right? It's on top of the regular paid sick leave. But if you're not operating in if you're not operating in the county of LA, like an unincorporated area of the county of LA, are you?
Yes.
Okay, well, in that case, then yes, you are, regardless of what federal additions or revisions that might have taken place. If you are operating in an unincorporated area of the county of LA, then
No,
yes,
he's in Van Nuys. He's in the city and county of LA.
I see. You're in Van Nuys. Okay,
Yeah.
So he's in the city and county of Los Angeles.
right. But
So
are you in the unincorporated area?
no, he's in the
you're
city
not.
and county of Los Angeles.
Right. So I don't think this applies to you. What I want to do, Steve, I'll send you a link that basically will help you check for your address. And
Okay, it's Kristina. I can 100% tell you he is an incorporated area. He is literally like you're in Encino. The city,
yeah,
Van
that's
Nuys is
what
not
it
a
sounds
city.
like.
It's part of the city of Los Angeles.
So it doesn't apply to you. How many employees do you have?
8.
Oh yeah, no, you're good. You don't have to provide it. I will have to check what Nancy is referring to in terms of the federal update, because we'll have to check to see if it applies to you, given that you have 8 employees. But the local ordinances are not gonna be applicable to you because you have less than 500 employees, which is what the city of LA supplement paid sick leave applies to. And the county of LA is only for those who operate out of unincorporated areas, and you're not in one.
Okay, so I don't have to give them the extra sick time off.
No, you're only on the hook for the 6.
Thank you.
If they're part-time, if they're accruing, they may not reach that.
They're full-time, but
Oh,
okay,
they're
thank
full-time.
you.
Yeah,
Thank
you're
you.
welcome.
Okay, can they work from? Okay, can it? So if someone has COVID, you have to have them not be at the workplace for 5 days. You said.
Correct. They got to test after the 5th day. Yes.
Can they work from home during those 5 days and still work?
Well, if they're working, then they're technically not qualified for paid sick leave for
But
some.
that's not what the question was. The question is, earlier it was they have to take off for 5 days. That's what you had said earlier. If someone tests positive, they have to be excluded from the workplace for 5 days.
Oh, sure, absolutely.
So,
Yeah.
but are they allowed then to work from home versus
Of
them taking sick leave for those 5 days?
Absolutely. If it's a company and the position that allows them to work remotely, perform their job duties, then absolutely, by all means,
Okay,
yes.
because we've had people ask us this many times, that their employees don't want to work and they think then they could go home, and they are able to work from home. So that if they're able to work from home, they can still work from home during those 5 days.
Absolutely.
Okay. Is there any specification of which COVID tests are acceptable?
So the antigen tests are the ones we got to use now, because if you take the other ones, you're going to keep testing for, up to 90 days. So any test that's basically an antigen test, that is I think everything that's now purchased over the counter is fine, as long as
no PCR tests.
no PCR tests, because then like I said, then you'll never test negative. You're
Right.
not going to test negative for a while.
Yeah, so you shed the virus.
Exactly. Yeah.
Okay. So you have to use an antigen test. For the pay transparency reporting, is the 100 plus based on number of employees from 2022 or starting now in 2023?
That is a really good question, and I don't know the answer to that. So that's something that I'll have to check to see in the forthcoming guidance. But I mean, presumably it's the number of employees that you currently have. But then there may be a look back period that, I'll have to double check and let you know.
Okay, Blanca, we will let you know that answer.
Yes.
Where can we find a template for the written notice for tracking vehicles?
I can provide one.
Okay, that'd be great.
I can send that to you next.
And then just send everything to Fiumi since I'm going to be gone.
Okay.
So on Cal Savers, how are employees to be notified of Cal Savers? Should the employee handbook mention the program if they don't have their own plan?
Absolutely. Yeah, that's what we're doing. We're basically putting it into the employee handbook. So
in the meantime, if it's not in the employee handbook, how does the employer notify the employees?
I mean, typically, if you don't have an employee handbook, you just basically have a standalone policy, or you just talk to employees if you're a small employer and basically say, we're implementing this. Most of my clients find out about this because their payroll system triggers a little alert that says, hey, you're required to have this thing. Then they just have a conversation with their employees, or they have a written policy or an email. There's no like specific way, but as long as you notify your employees that this is available to them, then you should be fine.
Okay. Pay transparency follow-up. Does the May reporting for pay transparency apply to out-of-state employers?
To out-of-state employers?
So Russell, so the employer's out of state, but they have employees in California. Is that what you mean?
Yes, and they have more than.
Yes.
They have to do the California reporting in May.
Yes, absolutely. Then yes, it does apply, because
But
it's
only for their employees that are in California, though.
yes, that's correct.
So
Those that are in California.
So a company out of state with one sales rep in California has to report only for that California rep, not their whole workforce.
No,
Yes. Right?
I think the answer is yes. Yeah, I think the answer is yes. And this is another follow-up that I'll have to do, because again, I'm not really sure how they're calculating how many employees. This is something I have to follow up on.
Okay. Do we have to accept self-administered, self-read at home COVID tests, or does the employee have to go somewhere and get a test?
Self-administered is fine. They can, as that's what most of my clients have been doing now, is you basically, as long as it is a standard FDA approved test, that shows the result, and they show it to you and it looks legitimate, then I would accept it. Some companies have a requirement that you do the test via Zoom. So in other words, they watch you do it, and then you look at the result, and then you can do that. That's lawful as well. You can have one designated representative of your company who is in charge of basically being the witness for administering this test, even if the employee is doing it at home, self-administering. But as long as they can see you doing it, then that's fine as well.
Okay, so that's our last question. Does anyone have any other questions? Because we promised we'd have you out of here in an hour.
Yeah, and we're very prompt today.
Yeah, we are.
Can I ask one last question? I'm sorry to
No, Steve, you're not welcome.
elongate this.
About 30 seconds.
Real quick then, I have company vehicles that they are allowed to drive them during working hours, but they're not allowed to drive them after hours. If I cannot track them after hours, how do I know if they're abusing our policy?
Well, that's something that you have to vet your employees, and if you can't trust them, then you shouldn't have them driving your vehicles. I mean, I think the policy, you should have an internal policy that makes clear that a violation of your policy will result in termination, and I think make it very strict. But if you do have a written policy that makes that clear and that you actually enforce, that's the only way to find out. But you're not allowed to track them, not under this new.
That's really anti-employer, I'll tell you.
It really is. Well,
Yeah.
I know. I don't know why you're surprised.
True. Okay. Thank you.
You're welcome.
Yeah, and by the way, Steve, I totally understand what you're saying, because we have another member and they have their cars come back every night, but they have like a tracking system on the cars because they use they actually have someone that dispatches and everything, and they have to know where the car is, so they know who's the closest to send to the next location.
Us too. Yeah.
Right. And so then they send, but they have all the employees bring the cars back at night. They've always done that. But they do let like one employee who covers Palmdale take the car because he lives in Palmdale and just services that area. And so it's the same thing, right? How do you know if they're not using the car after hours? Unless maybe it's you have to have them send in the miles on the car when they're done at the end of the day, like, and in the morning. I don't know. I'm just like, give me an idea.
Yeah, you can come up with some ways like that, like Nancy suggested, but you cannot, anything short of tracking them.
Okay.
Should be fine.
Thank you.
You're welcome.
Well, as we mentioned at the very beginning, this PowerPoint will be available to you probably next week. We're very short-staffed right now. And the recording, we edit it so you don't have all like the little beginning chatter and everything of us talking about stuff. So it will probably be up on our YouTube channel, which on YouTube is GSFBCC, like Greater San Fernando Valley Chamber, GSFBCC. So you'll be able to find it there. Kristina will check on those answers and send them to Fiumi, and she will get them out to everyone. And I will be out of town next week. So if you need anything, you could contact Fiumi. And I want to thank everyone for being here, and Happy New Year.